We have a developing story today. A Supreme Court of Canada justice is under investigation. The Canadian Judicial Council says it is reviewing a complaint into the alleged conduct of Russell Brown. He's been on leave from the top court since February for what was described as a confidential matter. Now, we don't know the specifics of the allegation or the seriousness of it, but how could this impact the operations of the Supreme Court of Canada? To help make sense of it, University of Ottawa constitutional law professor Errol Mendes joins me now. Professor Mendes, thanks so much for your time. It was
very welcome.
It was unclear until today why Justice Brown was on leave. What do you make of where this leaves Canada's top court and its ability to function and reach decisions right now, down to judge?
Well, it raises some very problematic issues because while the investigation goes on with the Canadian Judicial Council, it could take some time. And in the meanwhile, there is a requirement to figure out if there is a major hearing coming up, which could require a decision by a majority. If there is an equal number of justices, there could be a tie. So I think the major challenge before the Supreme Court of Canada is to figure out if there is a major issue coming up, which could require the presence of Justice Brown. Could they go, for example, with a bench of 7 as opposed to 8 without Justice Brown, so that there is no chance of a tie coming out of it? And there's some very, very significant issues coming up before the court. One in particular is the Federal Impact Assessment Act, which actually focuses on Alberta. The Court of Appeal in Alberta basically called the act an existential threat to the resources of the province. So you need, obviously, an Alberta judge. There is one, despite if with his absence, that's Justice Sheila Martin. But nevertheless, it does present some challenges to the court.
Right, and Russell Brown is an Alberta judge. He is seen as perhaps one of the more conservative-leaning people on the court in his outlook, certainly not in a partisan way. I don't want to leave that impression. But I want to go back to the point you raised earlier. For people who don't know, there are 9 positions on the Supreme Court. This brings it down to 8. And as you said, it creates the possibility of a 4-4 tie on decisions. If we get to that point, what is the process? Like in Parliament, the Speaker breaks the tie. In the U.S. Senate, the Vice President breaks the tie. How does the Supreme Court deal with something like this?
Well, there is not going to be a tie. I think the Chief Justice will basically have a bench of 7 and maybe even delay rulings on major issues such as the Federal Impact Assessment Act until the investigation is over. There is a chance that the conduct investigation will find that Justice Brown has not done anything which requires a misconduct removal. So I think we should not go as far as the dangers of a tie. It's not going to happen. What we should focus on is to make sure that this process happens for due process for everyone involved. The Chief Justice has to take hands-on in terms of how he's going to structure the bench if any major issues are coming up, but I don't think there will be a tie.
Right, and certainly we're not drawing any conclusions on the conduct in the investigation. That has to run its course. It is this operational question that we wanted to explore. So how does the Chief Justice do that? How do they pick a judge to sit this one out and have it go down to 7? Is that normal practice, or is this sort of an extraordinary measure that the Chief Justice would have to figure out?
Well, that's going to require the Chief Justice to look at some of the issues coming up and determine if there are, for example, sufficient representation of key provinces, if then a major issue, and obviously with one that could come up, the Federal Impact Assessment Act, obviously you'll need Justice Martin to be there from Alberta. But on the other hand, these issues affect all provinces. The Federal Impact Assessment Act is equally of concern to Quebec, for example, which wants to keep its own jurisdiction on any form of federal control over major projects. So it'll be very much up to the Chief Justice to look at all the issues coming up. Also, keep a hand in on what's happening with the Judicial Council to see how the process is going on, because there is a chance that over the investigation of the conduct complaint, the council could say it's not warranted to go any further. So he has to keep an eye on what's happening in the Judicial Council at the same time.
I'm asking this in the abstract, not to cast aspersions on Justice Brown, because again, we don't know where this is going to go. But if any judge is found to have committed a form of misconduct that requires their removal from the top court, what is the process for something like that?
Well, the process is one which has never been actually triggered in recent memory, is that the Governor General would require a resolution to the Parliament, the Senate and the House of Commons, for a vote of removal. Well, it's only even the recommendation for removal has never happened recently. There's been 3 recommendations for removal of lower court judges, and they all resigned before it went any forward. So I personally don't think we're going to have the Governor General ask the Parliament of Canada for remove any judge. And I personally think that we should wait to see how the process in the Canadian Judicial Council is proceeding, not make any predetermined decisions in terms of whether or not it's deserved. Wait until the panel, which is then going to be tasked if the conduct is being found to be of concern, the panel in the Judicial Council will make that recommendation on removal. But I don't think we can even come to that stage as yet until we know what's happening in terms of the process.
Nope.
And very little is known right now in terms of what the nature of the conduct complaint is. So let's wait and see how the process develops over time.
No, absolutely. When you want to wait for a clear outcome before a rush to judgment. But just, I guess, to finally summarize your point, that even with a judge down under these circumstances, your view is that the court can find a way to function perfectly fine. It's just up to the Chief Justice to do some delicate stick handling, depending on what the issues are and how they're going to be approached.
Absolutely. There is no danger whatsoever for the Supreme Court of Canada to be hidebound in terms of this situation. There's always the chance to have a much an uneven bench, which makes sure that there is no tie decision. So let's not worry about these outcomes, which is not going to happen.
Okay, Errol Mendes, thank you so much for your time and your insight. I really appreciate it. That's Errol Mendes at the University of Ottawa.